Hello, my name is Professor Mark Lunney. I'm a professor in the School of Law at the University of New England, and what I'm doing today is to take you through the vexing question of how a dead snail made history, or did it. What I'm looking at today is the relationship between Lord Atkin and the case of Donoghue and Stevenson. Why are we doing this? Well, it's the 150th anniversary of Lord Atkin's birth. Donoghue and Stevenson is often thought to be the foundation of the modern law of negligence in Anglo-Australian law. It's one of the most important cases in the common law, and it's one that everyone knows. Anyone who's studied law either at school level through undergraduate degree, PhD, or even as a profession like me, everyone will know Donoghue and Stevenson. There are two other videos in this series. The first will discuss the importance of the case for the law of product liability, and the second will talk about legal reasoning. But my task today is to tell you what actually happened. So what we see here is a bottle of ginger beer, and it's a bottle of ginger beer which is at the heart of Donoghue and Stevenson. Donoghue and Stevenson is set in a cafe in Paisley, where two friends went to have a drink on a Sunday evening in August 1928. Mrs. Donoghue had a drink which was called a Scotsman's ice cream float, and that was ice cream with ginger beer poured over it. Now what happened was her friend very kindly bought her this drink. The owner of the cafe poured some of the bottle of ginger beer, very like the one I just showed you, over the ice cream which was in a glass. Mrs. Donoghue drank some, and then her friend poured the remainder of the ginger beer into the glass. Unfortunately, it wasn't just a ginger beer that came out. The partly decomposed remains of a snail also came out. Now, the ginger beer had been manufactured by David Stevenson, who was a local brewer of ginger beer and lemonade in Paisley. And Mrs. Donoghue alleged that she had suffered gastroenteritis and shock after realising what she'd done. Now, I've taught Donoghue and Stevenson all over the world, and I can tell you that almost everyone at one level has a sense of shock when they find out they've drunk ginger beer with the remains of a partly decomposed snail coming out. There were a number of important legal issues in the case of Donoghue and Stevenson. The first was who could Mrs. Donoghue sue, and in what kind of legal action? Well, the obvious person to sue would have been the owner of the cafe. That was the person who supplied the ginger beer to her. But there was a problem with her trying to sue the owner of the cafe, and that was that she hadn't purchased the drink. It was her friend. Her friend had purchased the drink for her. Her friend would have been able to have brought an action if she'd had been the one that had suffered the harm, because she would have had a contract with the owner of the cafe. But Mrs. Donoghue didn't have a contract with the owner of the cafe. And there's a long-standing rule, then as now, of contract law that says that only the parties to a contract can sue or be sued on it. Therefore, it was the friend that could sue in contract, not Mrs. Donoghue. She couldn't sue because she wasn't a party to the contract. That rule is called the privity of contract rule. So what Mrs. Donoghue had to do was to think and find an alternative legal remedy, and that was in the tort of negligence. She wanted to argue that the manufacturer, Stevenson of the ginger beer, owed her a legal duty to be careful in the manufacture of that ginger beer to ensure she didn't suffer harm. Now, the facts of Donoghue and Stevenson took place in Scotland, and perhaps you didn't know, but Scotland operates under a different legal system. There's a great deal of similarity between the Scottish and English legal system, but they are different. And this presented an even greater challenge for Mrs. Donoghue, because shortly before the facts of Donoghue and Stevenson arose, the highest court in Scotland had heard a case about another ginger beer manufacturer. This time there was a mouse in the bottle of ginger beer, and when it was poured, the partly decomposed remains of a mouse came out. And the highest court in Scotland said that the manufacturer did not owe a legal duty to be careful to a consumer like Mrs. Donoghue. And when Mrs. Donoghue brought her case, she went through the lower courts in Scotland up to the highest court, and guess what? The highest court in Scotland said exactly as it had in the previous case a couple of years before. She had only one option. She had to go to the highest court in Britain, which was then the Appellate Committee of the House of Lords. When the case reached the House of Lords, there were 5 members of the House who heard the case. Lord Atkin, Lord Macmillan, Lord Thankerton, Lord Buckmaster and Lord Tomlin. And by a 3-2 majority, Mrs. Donoghue won. It's often called the Celtic majority in the House of Lords because Lord Atkin, even though he was born in Brisbane, he spent most of his adult life in Wales, Lord Thankerton was Welsh and Lord Macmillan was Scottish. And so it was the Celtic majority in the House of Lords that gave Mrs Donoghue her victory. Now, the important part of the judgment as far as Lord Atkin was concerned was his principle of neighbourhood. Now, that wasn't in fact what all three judges held. All of them held that a manufacturer owed a duty of care, a legal duty to be careful, to the ultimate consumer, someone like Mrs Donoghue. But Lord Atkin went further. He talked about a legal duty being owed to one's legal neighbours. And that, in a sense, is what the case has become famous for, certainly as far as Lord Atkin's concerned. Where did he get this idea of neighbourhood? Well, certainly he got that from previous cases, and as one of the other videos will do, it will explain how his reasoning process reached that conclusion. But there's also some interesting personal touches here. Atkin had a very strong Christian faith, and there's evidence from a lecture he gave just before Donoghue and Stevenson in 1931, and also from the conversations he had with his family over the Christmas of 1931, that he was thinking in terms of the sort of biblical neighbourhood, that we all have a duty to be good neighbours to each other in the same way as his Christian faith had taught him. Now, as I mentioned, Donoghue and Stevenson was technically a case decided under Scottish law. But Lord Atkin was concerned about that. For him, this was a really big thing. It was important to get this neighbour principle out as a matter of law in the whole of the United Kingdom, and then as a consequence, in the 1930s, also for the law, either through precedent or through being persuasive, to the Dominions and Commonwealth. Now, in his first draft, Lord Macmillan had reached a conclusion in favour of Mrs Donoghue, but only under Scottish law. If that had been the ratio, if that had been the reason for the decision, it would have had much less impact because it would have been different from English law. So Lord Atkin, as it's come to light in the last 20 years, actually went to Lord Macmillan and convinced him to change his judgment, so that his judgment would be based not just on Scottish law, but to say that the law of Scotland and England was the same. In that sense, this new principle that was put forward would apply throughout the law of England and its Commonwealth, not just in Scotland. So the actual majority judgments in Donoghue and Stevenson are narrower than the Lord Atkin's neighbour principle. The majority simply say that a manufacturer owes a duty of care to the ultimate consumer. But it's Lord Atkin's neighbour principle which has been the basis of the expansion of the law of negligence. It's the one that was used to go beyond the facts of the case to impose legal duties to take care in a wide variety of circumstances. Indeed, we can really say, I think, that it's that neighbour principle that imposes obligations, on us as we go about our daily life to take care in the exercise of what we're doing. It really is a seminal concept. So, the question that I'm always asked is, ultimately, was there a snail in the bottle? And that ends up being a difficult question to answer. It's difficult because of the nature of the challenge that Stevenson made to Mrs Donoghue's claim. So what Stevenson said was, assuming everything that you say is true, including the presence of a snail in the ginger beer bottle, I do not owe you a legal duty to be careful. So the question for the House of Lords wasn't based on the fact of a snail being in the ginger beer bottle. That was assumed. So what the House of Lords said, the 3-2 Celtic majority, was to say, assuming all these facts are true, a legal duty of care is owed. For Mrs Donoghue to win her claim, what should have happened is the case went back to a court where then evidence would be led as to whether there was in fact a snail in the bottle or not. But things don't always turn out as planned. Stevenson died in December 1932. That created some legal complications. They were settled in early 1934, but the case itself was settled in December 1934. But in a very real sense, it doesn't matter if there was a snail in the ginger beer bottle or not. Lord Atkin's judgment is a masterpiece, a classic example of how the common law can adapt to changing economic and social conditions, the conditions in which it operates. So, next time you're having a glass of ginger beer, safe in the knowledge that the manufacturer has exercised reasonable care to ensure it's safe for you to drink, raise your glass and propose a toast to a Lord Atkin and, perhaps, to the snail that never was.